Hello? Hello? Can you all hear me? Is anyone here? Am I even live? I think I'm live. Oh, yes, I'm live. Uh, what do I have to do now then? Come out with that. Hello? Is there anyone there? Hmm. This is new to me. I'm a bit lost. Oh, hang on. Hello? Oh, hang on. Hang on. Properties. Okay. Hang on then. Let me sort this out. This is a new stream. Right. How do I do this? My Yes. This is brand new. I'm trying this for the first time. Can you hear me? Can you hear me better now? Hang on then. Hang on. Right. What about now? What about now? How's my audio now, Sarah? Oh, I know what's wrong. I know what's wrong. I know what's wrong. I think I got it. Right, I've got to play with it. Hang on. I don't mean my dick. I mean with the sound. Hang on. We'll get there. This is the first time I'm trying this, so bear with. Oh fuck! Bear with me. Bear with me, people. Right, how's that? Is that better, Sarah? Because I'm trying this. I've, fuck, hang on it. Right, I need to get this fixed then. I need to get this fixed. This is a practice stream. It's all good, so don't worry. It's a practice stream. Yeah, it doesn't really matter today if we don't get it right. Motherfucker. Um, um, how's that? Is that better sound? I think the sound is fine. It's the echo. Is it too far away, you think? Is it better now? Is it better now? Is it better now? This is what we need to practice this now because I'm having a mare here. This is Stream Labs. This is not StreamYard. Unless it's something on my one. Unless it's something, hang on. Maybe I need to go webcam and do it. Oh, hang on. Hang on. Hang on. Hang on. Hang on. That's better. That must be better, Sarah. That must be better, Sarah. That must be better. That must be better. 100% gotta be better. 100% gotta be better. Gotta be. No slightly about it. This is slightly about it. This is it. This is it, Sarah, isn't it? This is it, Sarah, isn't it? This is much better. This is much better. If anything, I'm too loud now. I'm too loud now. Right, hang on then. Right, hang on then. Webcam. How the fuck is there two? Fuck is there two of us? Of us. Let me check it. Let me check it. Right, it's echo, isn't it? Right, okay. Echo, isn't it? Right, okay. Audio output. Audio output. I'm just pressing buttons now. I've no idea what this is doing. No idea what this is doing. Hello? Hello? 100% gotta be better. 100% gotta be better. Gotta be better. Be slightly about it. This is slightly about it. I'm just pressing buttons now. I've no idea what this is doing. No, not that one then. No, not that one then. What about this one? What about this one? No, not that one then. What about this one? What about this one? With me, whoever's here, with I know whoever's here, I know there's more people here. Literally don't know what's going on. Literally don't know what's going on. Okay, crossbar, crossbar. What this? What this? How is this now? How is this now? Who's this now? Who's this now? Who's this now? This is a. This is a. Right, I'm right. I am right. Played about with this. I am. Played about with this. I am. It's like there's two audios and only one. Okay. Okay. Audio. Um. So I've selected the right device.
Selected the right device.
But, but it seems like I've not
But it
done.
seems like I've not done.
Hi, Melissa.
Hi,
I'm so
Melissa.
sorry.
I'm so
messing
sorry.
this up today.
I'm messing this up
I
today.
messed in streamer.
I messed in
This is
streamer.
the first time I've ever
This is the
tried
first
to do
time I've ever
this.
tried to do this.
So bear with me, please.
So bear
I'm
with
having
me,
a
please.
mare.
I'm having a mare.
I'm having a
I'm having a
friggin' mare today.
friggin' mare today.
What am I doing?
What am I doing?
Right, let's.
Right, let's.
Hello, hello,
Hello, hello,
hello. Oh, hang on.
hello.
I think I got it. Hello, hello. Is that better? Hello, beautiful people. How is that? Sarah P, is that better? Is that better, Sarah P? No echo, doesn't sound too far away. That should be much better. That should be much better, Sarah P. That should be the best. I'm the best around. Shouldn't be any more echo around. I'm the best around. This should be the best sound you've had. This is the best around. So, right, so, okay, so the volume for me for it is a max. It's at max. Let me go to properties then. Um, okay, got that one in. But literally, it's at 100%. I can't go up anymore with my volume. Can't even be. Hang on, let me hear it myself on my thing here. I think that's fantastic. I'm a genius. I feel like a genius right now. I feel like I've fixed everything, the whole world. This is the first time I've ever used this Streamlabs stuff, so you have to bear with me. I don't know what I'm doing. This is the first, well, I've had practice runs, but they've all gone disaster. So this is the first time I'm trying it. Right, let me get this up then. Anyway, welcome everyone. Right, I can't put stuff on. Oh, hang on, can I? Hang on. Let's see this then. Hang on. Hang on then. Okay. I think. I think if you type something, this might be the chat box. Someone type something, see if the chat box works. Don't worry, I could do it. No worries, no worries. It's probably not you, it's probably me. Here we go, the chat works. Yeah. But look at the screen. Look at the screen now. Ah, look at the screen. How good's that? I'm a genius. Right, is that too small? That's what they all say. Hoi, hoi. Right, I don't have to have it on screen, but I just thought I'd try it to see. I'm just trying different things here. Right, I need to put this on now. Here we go. Right, how's that looking? I look at this. Hang on. Ah, you see? She didn't just donate, but I can click it. That's good. That's where it goes, you see. And same thing when I get a member, when some subscribes. And he didn't just subscribe, he subscribed it a month ago, but still. Right, let's see if this works then. Because I can do it. So essentially, in the background for me, yeah. So I can go like this. So I go refresh. 3 days ago, you sent me $1, so I can just go Sarah P donated. So should come up on my screen when people donate, and then it's fine. Like I've donated and I can do it. So it's not nothing new. It's just that's where it goes. But I think that's too loud. So if I just turn that down a little bit. No, it's not charging you. No, no, you're not being charged. No, 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 no. No, 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 no. Not being charged one bit. Don't you worry. Right, let me put it down. I bet you were flipping out. I bet you were. I'll just do mine. There we are. No, so it's just the back end. So I can see here, I could, like, for instance, great success, subscribed 21 days ago, right? And I can go, do you know what I mean? So I can, if we miss one, I can just replay it or something. That's all it means. Look at you panicking. Panicking there. I can imagine you panicking as well. Uh, you've probably got off your head, like, right. Let's play this video then, see if it works. Got it. Get it? Got it? Good. So yeah, don't worry about any of that. Oh, right, I need to put my logo now. Image? No, that's my image. Where's my logo gone? There. How clever's now I know how this works. How clever is this? I'm gonna turn my audio down a little bit. Is that alright? Oh, hello. Hope that's okay as well for everyone. Say hello in chat, whoever's here. We're just having technical difficulties this morning. Also, do you like the chat being on screen or not, guys? Sarah, do you like it on screen or not? Or do we just take it off? Oh, he's in now with that. Yeah, he's in scrubs now. I'll see what other people think then. I'm not sure what they think about it. Because you've got the side anyway, so it really doesn't really matter. You don't really need it, do you? Oh, it came back with a verdict after 50 minutes, Sarah, last night. Verdict came in. Guilty, first degree guilty on the first two counts, and guilty for the child molestation as well. So they were literally less than an hour, Sarah. Less than an hour. So today, they're just discussing some terms for next week. Yeah, that's what I thought, Melissa. That's what I thought. That's fine. You know, I can because I can hide it. You know, anytime I can look at that. Look at that. I just hide it. Do you know what I mean? Just does. Yeah, I agree. I agree. They had a verdict straight away. Do you know what I mean? Wasn't even wasn't even close. Um, the only bad thing about this, guys, is I can't put stuff on screen. It doesn't seem. Here comes a judge. Here comes a judge. Here comes a judge. I need to maybe put this up a little bit.
Good morning, everybody. Let's go on the record. 19 CF 7518. I have Counsel of State Defense. Mr. Quellis present. Good morning, everybody. I wanted to have a status court date ahead of next week to go over some preliminary issues regarding jury instructions, things of that nature. That way we can get started rather quickly on Monday with the jury. I told the jury 10 o'clock. Does that time work for everybody? I kind of set it off the cuff, not talking to counsel beforehand. I just wanted to avoid some rush hour traffic for them, and then that gave us some buffer time if we needed something Monday morning over the weekend. Before I begin, is there anything else that we need to handle from any party's perspective before we go into some of the instructions, first from the state's perspective?
Very briefly, Your Honor, we had discussed with family that statements we are, for the moment, we have state in a tough predicament. We didn't ask them to write those before verdict, so unfortunately we can't hand them to the defense this morning. We have asked the family to get them to us by Sunday. They've agreed to do that. As soon as we get them via email or otherwise, we will cancel them. It'll also have identifying who the family elects to speak. We want obviously those. It'll also have identifying who the family elects to speak. We left them with that decision last night. Other than that, that's all the state has. I just want to make sure the letter we will get the last package. Other than that, that's as soon as we get them, we give them an opportunity. We're going to check and get the package. They're in. Otherwise, other than going
Does the state plan on reviewing the statements prior to getting them to the defense as well so the state themselves can look at it, make sure nothing objection from their perspective, and in that way, not watering it down, but making sure it complies with the statute?
Yes, sir. We're very aware that this is more about her IS, more child, and IS is we will read them with that eye. If we think there's anything beyond what we think the purpose of this particular phase, we'll obviously strike those statements ourselves. But if there's anything left that the defense objects to, we'd like to get it to Sunday. So they can, yes, sir, we recognize that if we get to a specific year down the road, there may be additional comments they want to make, but we've asked them to write it from an impact perspective, the impact of this child IS to the community. We'll, of course, review those to make sure that
Okay. Anything from the defense perspective before we go any further?
Sure, Judge. And I know I reviewed the order back before we started the trial from Judge Carbula as to specifically this issue, and I remember there being some details of exactly what procedure we needed to follow. So I will review that again to make sure. And if I'm not mistaken, I believe it even said it has to be read word for word, and that the family needs to be advised that they can't deviate from that and those type of things. So I would just request that we all review that beforehand to make sure that we're in compliance with that order.
we concur, Your Honor. We've told whoever is going to be there, they will ask to be sworn, prepared in advance. Whatever the defense agrees to will happen. We also have talked to them already about the very, very best they can maintaining their motion. Said that to them repeatedly. We have a victim advocate that sits with the trial and has already been telling them they're my person in the trial. The court probably would test and the record would show. Didn't have any of that during the trial, so we don't at the penalty phase, particularly during the testimony. We will tell them, of course, if they begin to break down what we usually advise them, and how we would certainly do that in this proceeding, is to just look at the court and ask for involvement. Like they are going to break down, we would ask the court then if they say that to the court, to try to limit any emotional, which of course we could always expect, but we do try to ask them to hold that in. But I try to signal to the witnesses if they feel like they're going to get emotional, to look at the court, not us, and say they have a moment of honor, and that would be an indication they're about to have some emotion that they can control. That one we would ask the court for that, or even any of that. So we always do that. We will do that in this case, and of course comply with counsel pointed out.
So you're
And Judge-
saying that would be the code word. When they look at me and say, may I have a moment, that would be the code word to say, I need to excuse the jury.
Yes,
Okay.
You're asking the court to recognize that they do that.
The defense agrees with that procedure, and we will instruct our witnesses in the same manner to do the same. I mean, I think it's emotional for both sides considering where we are. And so that's obviously, of course, we're not opposed to that at all.
So the order Judge Carbula entered, I pulled it up while we were going over just to talk about it. It obviously said the state would work with the victims regarding preparing the statements, knowing what the statute allows and does not allow, obviously not about the defendant, not about the crime, but about the victim and their uniqueness. And that you'll explain what they can and cannot say pursuant to law, as you've already explained. Once they're finished, I'm just going through the order now, just so since we're talking about it. Once it's finished and reviewed by the state to ensure that the statement is admissible, so the state will have an obligation to review it to make sure it complies with the statute.
Yes, sir.
It can then be provided to the defense for review, including the defendant, of course. After review, the defendant can consult with the state regarding any objections to the statements. All agreed upon redaction shall be made, and a clean copy of that statement can be prepared. So anything that's objectionable or objected to and the parties agree can be taken out, and a clean copy is prepared. And then it says, prior to trial, the state shall provide a final draft to the court, and the court will hold a hearing to hear any and rule upon any objections. So you can do that Monday morning. So you guys talk Sunday night, early Monday morning, send me a clean a copy of what the state believes they can present, if there's any objection, maybe cross through it in the line item in the document. Track through, I think is the phrase for a Word document. You track through it or something, and then track changes. And then send it to me, then we can take a look at that early Monday morning. But I assume you guys will work through most of those issues to assure there's no appellate issue on that.
Yes, sir. If they do object, we will most certainly, without knowing what they are at the moment, we generally agree. We know this is something not argues a factor. If there's an objection, we will look at it with a certain cautious eye. Likely. If there is any disagreement, Your Honor, I believe that.
And then it also says how to handle any objections. If we get to that point, hopefully we don't. It also says that the state will instruct the witnesses to read only the statement verbatim, not to go off script, to offer any opinion or characterization about the crime, the defendant, or the potential penalties. And that's essentially it. And that, just so you guys know, that order by Judge Carrillo was entered on July 14 of 22. It's on docket line D322. You guys want to take an extra look at it? Anything else from the defense perspective?
No, Your Honor. We did speak to our client just briefly about he's entitled to a PSI. We've not completed that conversation. We just began talking to him about that this morning. So we do need to address that a little further to make sure that he is going to waive that or not. Is there anything else that we?
I would have, depending on the jury's recommendation, I would have intended to order PSI.
Correct.
Next week, depending on what the jury does.
Okay.
But if I'll have to look at the statute to see whether it's even waivable. I don't know, given the penalties.
Understood, Judge.
Okay, so I have in front of me, I printed it out this morning, the defense's pleadings filed on 8/10/23 regarding a list of non-statutory mitigators and a list of catch-all mitigators. I wanted to talk about this to make sure I incorporated everything the parties want me to incorporate in the jury instructions. I did email out this morning the preliminary instructions that I read to the jury. The preliminary instructions, of course, do include the aggravators alleged by the state. What I want to do is first talk about the aggravators alleged by the state, since that's what's included in the preliminary instructions, and then we'll kind of work our way through it that way.
Yes, sir. President, remain seated.
Yes, you guys remain seated, be comfortable as best as you guys wish. So state your notice of intent with the aggravators was filed back on August 8 of 2019. It was filed by Ms. French. It included 7 aggravators. Are you proceeding on all? Are you dropping any of those aggravators, or are you proceeding on all 7?
Your Honor, yes, as we sit here today, Judge, and if you want to go through one by one, that's fine.
I probably will. I was asking the
Yes, sir.
first catch-all question.
Well, yes, but I would note the court has 1 through 9 on the preliminary that you sent this morning.
Yeah, that's not an accurate statement. That was me putting everything out there the best I could, and then I would narrow it down based on conversations during court today.
Yes, sir. So the ones we have, obviously, we have always intended on proceeding on. However, the state is intending on looking at the HAC aggravator case law more this weekend. As we sit here at the moment, we do intend meeting, recognizing if we abandon it, obviously that would inure to the defendant's benefit, being no prejudice to him. So with respect to what we have on the notice at this time, yes, sir, the only potential announcement that could change would be as to H, which is the fourth one listed on the notice, the especially heinous atrocious cruel aggravating factor. We have some case law we believe supports our position, but we would just ask the board for the weekend to look deeper into that. But otherwise, yes, sir.
Okay, let's go aggravator by aggravator then. The first one being previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. The standard jury instructions talk about previously or contemporaneously convicted. In this case, I think we only have a contemporaneous conviction. What conviction are you moving forward on?
It's this one, Your Honor. Count 3 is the one that first aggravating factor is relying on. I would note for the court that contemporaneous convictions involving other crimes committed on the homicide victim cannot be used to prove this aggravating circumstances, this aggravating factor. However, that's Lamb v. State, 532 Southern 2nd, 1501, Supreme Court case here in Florida from 1988. However, if the felony was not contemporaneous, although the same victim was involved, the aggravating factor should apply. But that's why we're relying on count 3 in that site. Bogle v. State, BOGLE 655 Southern 2nd, 1103. Another Florida Supreme Court case out of 1995. So in essence, Your Honor, yes, so long as it can be the same victim. So, and obviously, we've never, in our closing argument, the evidence, there's no proof whatsoever factually that the sexual battery was occurring in the 1920 time frame of December. We've articulated very detailed manner that one date that we know that we alleged and that the jury's now found with respect to the sexual battery was July 7, 2008. Furthermore, Judge, we'd also cite to Buzia v. State, BUZIA 926 Southern 2nd, 1203, a Florida Supreme Court case from 2006. And that case stands for the proposition that a jury finding of guilt before adjudication is prior position. So our position with respect to count 3 is exactly where it sits now. This court doesn't adjudicate yet. That still can't qualify as this prior felony. So our position is, as we sit here, we are proceeding on that aggravating factor based on case law, citing the fact that acts that we're alleging have occurred or earlier in this relationship. The jury's heard all these facts. There's no evidence whatsoever that any sex bat happened at the time of the murder. So our position is count 3 is the aggravating factor of a felony involving the use of threat of violence to the person. Obviously, sexual battery is qualified.
Here's my question, State. The standard instructions don't define, I mean, obviously we know what a capital felony is. Jury instructions aren't defining the felonies involving the use or threat of violence to another person. Obviously, the facts of an underlying sexual battery could be a wide range of underlying facts.
Yes, sir.
In this case, based on the evidence we heard, I'm not sure there was any use or threat of violence that came out of trial. That's my concern at this point, and I don't know how the case law talks about that.
Yes, sir. I will tell the court Hess v. State, 794 Southern 2nd, 1249, Florida Supreme Court case out of 2001. Quite frankly, stands directly what the court is Heskey states to answer the proposition that any sexual activity with a child is a crime of violence.
So the jury instruction would read as follows. Jonathan Quayles was contemporaneously convicted of a felony involving the use or threat
or threat of violence to the person. The state will keep its comments to sexual activity with a child as a crime of violence. We're not going to, the state would withdraw an objection if we were to say something's not in evidence, like certainly he held her down or used a weapon. We would never make any arguments like that in the penalty phase. We would stick with the base proposition that sexual activity with a child is a crime of violence. He has authority over her. Things along that nature. We would never want to say that sexual battery was used with an instrument, a weapon, he held her down, or anything of that nature. We're going to stay with what the case law permits, which is any type of sexual activity with a child.
So then the way the jury instruction would read is as follows. Jonathan Quayles was contemporaneously convicted of a felony involving the use or threat of violence to another person. The next paragraph or sentence would read underneath it is the crime of sexual battery is a felony involving the use or threat of violence to another person.
I would say would be
Sense? I mean, this is not going to bind you. If you want to, we can always re-engage it on Monday.
Congratulations to Little Peanut. No, I wanted to test it out to see if it'd come on screen, but it didn't. It did not update my members' little group. Hello, Tuddy Pip. How are you, Tuddy Pip? I've got a new stream. I'm testing it out. I am. So I don't know how to work it. My PayPal payment, I did a $1, came straight in, went to the box. Happy days. But I did a membership and didn't go into the box. So I don't know what happened there. But welcome, Tuddy Pip, and also welcome Little Peanut to the wenches as well.
Just the platform to say anything you need to for the record.
I was researching this issue, and I have not found any case law contradictory to what Mr. Skinner said as of yet.
Okay, then the second aggravator, capital felony was committed while the defendant was engaged in or was an accomplice in the commission of or an attempt to commit or flight after committing or attempting to commit enumerated felony and or felonies.
the only one we're alleging there, Your Honor, if you instead of an enumerated felony, insert sexual battery, which they found. As to that aggravator, we are arguing that the ongoing relationship in finding count 3 was already found by them. The sexual battery is what we're not saying act X, we're saying this, that's the reason you see in the indictment we had 5 on it between dates all the way up to 20 and 2000. That this was during the commission of sexual battery because as we saw from the specific evidence, Snapchats, ongoing manipulation and the abuse of this child and sex acts.
You're saying that the way it should read is because there's a lot of commas in that aggravator that if you don't read it carefully can be very confusing. There was no attempt here, so or accomplice. So the way it should read is as follows: the capital felony was committed while the defendant was engaged
In
flight after committing sexual battery.
if the defense wants any or all of that language, the state will not object, just so our record's clear. If the court's limiting some of the language that's in the standard instruction, we defer to the defense. It's up to the state to explain that this murder was committed while the defendant was engaged in
Mr. Davis, Ms. Michelle.
Hi, Amy. Right, let's have a look at it. Right, let's try this gift again then, to see if it goes in the box. LH. Right, LH got it. But still didn't go in the bloody box. Welcome, Amy. So welcome LH to the Blue Wenches as well. Oh, it just doesn't update the box though. Do you know what I mean? I wanted to update the box. Also, have you noticed, Sarah? Have you noticed the bot's gone? Stream Elements bot has now gone. I managed to do it. I thought it was in here, it's in another box. I got rid of it. Yeah, I got 2 new Blue Wenches, but it's not topping up to the box. The members goal for end of October, you see it? Bottom left. I set my goal of 150 members from now until the end of October. And we just had 2 today, but they don't count because it didn't go in the box. My PayPal payment was straight to the box. That worked, but not my members one. That's a nightmare. But we'll try and fix it. It's all good.
And Judge, you did say we could sit. And just to be clear, in reading this, I interpreted it as 3 separate options: engaged as one, and accomplish in the commission of flight after committing as one, or attempting to commit as the third. And I just want to make clear,
Can
obviously,
you repeat that again?
the 3 versions of that would be engaged and accomplish in the commission of flight after committing, or attempting to commit. Those are the 3 options. And so obviously I don't disagree that they might argue about being engaged in, but I don't think the other 2 are relevant to anything that we heard in any evidence during the trial. I don't think there's anything that he was an accomplish in the commission of flight after committing something, or that he was attempting to commit at the time either. So if anything, I think maybe just to make it clear and to limit the amount of confusion would be to eliminate the other 2 after engaged.
Your Honor, for the record, the state's not opposed to that. There was talk of them running away. Now, we argued and made it clear that was a ruse to get her to school. So we do concur that we never thought the defendant.
Do you mean to the papers anyone do with like, no, I don't think they do. I know, sorry, some people do, yes, but most people don't do this because most people don't want people to find out how many members they got and stuff like that. Do you know what I mean? It's got to be secret, you know, to the people. It's got to be secret for most people because if they don't fill it, they're ashamed and stuff like that. Or some people you might think have got like 1,000 members, but actually they've only got like 100 something. So they don't want people to find out how much actual money they make. So I'm an open book. I just want people to see, but it doesn't work. It's a pain.
Or is there evidence that he truly was intending on fleeing from the sexual battery? However, it was a ruse. I will tell the court our argument has been largely it will be based on engaged in. So if the defense does not want that language of accomplice or flight, I'm not going to object. We realize how serious these aggravated factors are. So if they don't want that language, we're not going to stand in the way.
Thanks to the bit.
Just to make it maybe a little bit clearer, I don't think those are 2 separate things. I think it says that accomplished in the commission of flight after committing as one option, not he was an accomplice or he was in flight. So maybe that's just my interpretation of it, but if you can look at it and let me know if I'm reading that wrong.
The way I would read it, given all the commas, is that I'm going to get rid of the accomplice or attempt language. I'm going to read it as if that verbiage was not included in the aggravating factor, because we all agree that's not what we're talking about.
State agrees.
The capital felony was committed while the defendant was engaged in the commission of or flight after committing sexual battery.
The state does not oppose that. The state would concur with the
The state's saying they're not even going to argue flight.
No, I understand, Judge.
And so the question becomes down to, do you want me to read it as I just phrase it, getting rid of the accomplice and attempt language, and just pop engage in or flight, or just mention engage?
Judge, our preference would be to just have it as engaged if there's no true evidence of the flight. I know that there was mention of running away together and
Correct.
things along those lines, but not in that sense of what this instruction is for. But again,
So-
defer to the court on that.
Let
But
me ask you this question. Are you arguing flight?
The only time, if the court leaves it, what we would intend to say is the state of Florida never believed the defendant was flee. His purpose was to kill, to avoid having to. It was a ruse to get her from the school. So we agree there's not evidence that we would point to that he truly was going to. In that light, there was testimony that the argument could be made, but even so, if the defense is objecting to it, we are not going to, we will not ask the court to give that instruction lodging an objection.
and we would, Judge. We would. Our preference would be to just leave it as engaged.
For purposes of the state's record, make a record of our argument. That's why the indictment has all those dates it comes, all the way up and through December 20, 2018. Our position is, really, we could only pinpoint one date, while there are multiple ongoing, as the indictment alleged, of several acts of sexual battery. We charge one count on or between those days. So that's why we have it covering all the way through the homicide. Not to mention the facts bore that out, but also the jury's finding bore that out. But now, with respect to this aggravator, it's in the commission of, based on even just the dates we have charged. So we concur with that.
Okay, so the way I have it written down is, you guys will get a hard copy of this as well to review over the weekend. We can talk about it Monday morning if you think about it over the weekend more. The first-degree murder was committed while Jonathan Quaylez was engaged in the commission Hold on a second. I'm sorry.
So welcome everyone, thank you for coming back. I know this is a boring bit, there's not much on, but I thought I would stream it anyway, just to say thank you for everybody for the support over the last week and a half, or longer. Don't be shy, Sarah P does not bite, so feel free to chat whoever's here, say hello, love to see people say hello. And I'm just playing about because this is a new stream layout. This is Streamlabs I'm using now instead of StreamYard. So everything's new to me. So I'm just trying to. Look, I could do this. You see? Oi, oi, oh, 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 oh. No, what have I done now? Oh. Oh, there we are. Jesus.
Wade's reading makes no sense. The first degree murder was committed while Jonathan Quaylez was engaged in the commission of after committing sexual battery.
I would just say, Your Honor, the first degree murder was committed when the defendant was engaged in sexual battery.
Engaged in after committing. So was the first degree murder was committed while Jonathan Quaylez was engaged in.
Engaged in or during the course of.
That's not what this says. They're not during the course of. That language is not in the aggravator.
What I was going to suggest, Judge, is the first-degree murder was committed while Jonathan Quilla was engaged in or after committing.
That's not what it says. We're adding language to the aggravator. I'm not doing that.
I agree with the court. Does the court or the defense disagree with this? First degree murder was committed when the defendant was engaged in sexual battery. It's up to the state to argue that's then they're finding.
No, because it does not say that. It says after committing the felony. You're saying while engaged in sexual battery, as in it's currently occurring. That's not what the language says. The language, and just the way it's phrased is confusing. Because of the commas, if you get rid of the commas in the accomplice and the attempt language, it does, or in the flight language, it does not make sense.
But is the court reading it like the flight after committing? Meaning that's
That's what it says. It says or flight after committing.
and the state's not disagreeing. That's why I'm saying if we're eliminating flight at the defense requests and with their objections, then the only thing left would be the first degree felony was committed when the defendant was engaged in sexual battery. Now we concur, the state of Florida concurs, it won't argue if sexual battery is happening on December 19th or 20th. All we're going to point out to the jury is this was an ongoing relationship of sexual battery.
I got it.
Okay.
Let me read. The first degree murder was committed while Jonathan Quaylez was engaged in the commission of it still doesn't make any sense. I'm sorry. If I got rid of all the language but the engage and the flight language, it reads as follows. First degree murder was committed while Jonathan Quaylez was engaged in the commission of or flight after committing sexual battery.
Thank you, Amy. You didn't have to, but
I don't disagree with that.
thank you so much, Amy, and thanks for telling me because I don't get to see it. Whenever I go in the shop, it doesn't tell me. It tells me someone's bought it, but it don't tell me who. So thank you, Amy. That's very generous of me. Thank you so much for that. It does mean the world to me. It helps me out a great deal. So champion, thanks, Amy. You're the best. I won't sing. Don't worry, I won't sing. You're the best around. Thanks, Amy. And thanks for letting me know. There's nothing worse than when you see someone's bought it and you're just like, who's bought it? So cheers.
Especially, I pulled up the current statute as of effective as of today. And I'll read it for the record.
Yeah, I have it in front of me.
Yes, sir. And it does reflect exactly what the court just read. That is the language.
It just doesn't make any sense. Engage in the commission of or flight after committing sexual battery. So basically it's saying that he was engaged in the commission
Hi, Terry. Hi, Terry.
of sexual battery or of flight after committing the sexual battery.
Not you, Siri. I said, it's not you, Terry.
We can all agree this,
Siri.
the first degree murder did not occur while he was engaged in sexual battery.
Yes.
So that's not, so that language we're talking about is not even applicable.
But it is, Your Honor, legally because, I think we're saying two different things. Factually, the state will not argue that there was a sexual battery incident occurring in 1920. However, their finding was the dates and the indictment.
I got it. I think I have a better understanding. Give me a second. I think I have the language down.
So those that are late or not sure what's going on, they found the guy guilty on all 3 counts. I think it took, well, from the time they went in...
The first degree murder was committed while Jonathan Quiles was engaged.
To the time they got out, it was about an hour. So it would have probably taken about 30 minutes.
West then would be the commission of, not during, but was engaged or in the commission of sexual battery.
It doesn't say or.
What it does, if we strike wasn't accomplice.
The or is in the commas. The or goes to the accomplice. You're either engaged in or an accomplice.
Then we would ask the commission was engaged in the commission of, not during.
And that makes no sense. Was engaged in the commission of after committing or attempting to commit sexual battery?
Reading directly from the aggravated factor of the statute, that's what it says.
Tell me how that sentence makes sense.
Well, it makes sense because
Yeah, how about this?
it's in the indictment.
Let's put a pin in this one. Let's come back. It's now 11:34. You have a 12 o'clock meeting that you're not going to make at this point. The next aggravator that is alleged is the murder was committed for the purpose of avoiding or preventing lawful arrest or effecting escape from custody.
Yes, sir.
So the language I have is the first degree murder was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody.
Yes, sir. We're obviously arguing for preventing a lawful arrest.
Never say sorry to the Pip. So sorry, is this a guy that ended the young girl? Yes. So he was found guilty on first count of murder of his niece and first degree murder of the unborn baby, and also he was found guilty for molestation of a minor under the age of 18, or between the ages, sorry, of 12 and 18. So that's what he's punished for. So what they're doing now is, what happens now in Florida is the jury, I said they were out for about less than an hour. It took them less than an hour to decide because you had to sign all the forms, sign them all, get a judge, get everyone back in court, and it was exactly an hour to do that. So I imagine it took them about 30 to 40 minutes to decide. So what's happening now is a penalty phase. So yes, you got it, you got it. It goes on to DP, death penalty. So this is what they're doing now, is the instructions for the jury. Next now. So this is what they're discussing now. So on Monday, 10 o'clock Eastern, there's a penalty phase. And that means like everyone gets to come back now well, I think there's the state, I think I've got 15 people to speak. And the instructions, obviously the defense will have some people as well, and then the 12 jurors will go and deliberate whether he gets the death penalty or not. And in order to get the death penalty, they need to get 8 yeses, 8 out of 12 to say yes. In order, so the jury aren't there today. The jury got a day off today. So it's just these guys. They just started about an hour ago, just discussing this, and then Monday, full day again Monday, and then I'm not sure how long they're going to take. They'll probably take a little bit longer. I think Sarah said that, longer to decide. 10, 11, 12, 1, 2, 3 o'clock Monday, yes. 3 o'clock Monday to the Pip. So as we started about 2:45 UK time Monday, yes. So it's much better for everyone. So this is like 9 o'clock for Sarah P. She might not be late then, she might actually be on time. Do you know what I mean? So it helps us all out. Do you know what I mean? Helps us all out. Sarah P gets a lot of abuse off me for no reason. But I get a lot of abuse back.
Statement on the wire. That kid is mine. I'm sitting right here in jail with y'all. We'll be arguing he was avoiding a lawful arrest and sexual battery. It's very straightforward.
Are you in agreement with getting rid of the or affecting escape from custody language?
I'm not, again, I'll say this. The state's not opposed to that so long as the defense agrees.
That's fine, Judge.
Okay. So then the language is going to read, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest.
State agrees.
Defense agrees.
Number 4 is the standard HAC language. You said you reviewed that over the weekend.
Yes, sir, we agree with the language the court has in its instruction, all of it.
And so one thing I'm going to have to tell the jury too is some of these aggravator factors go to both counts 1 and 2. Some just go to counts 1, some go to just count 2. We need to figure out which ones I'm telling them go to both, which ones go to a particular count. And an example of that will be victim under the age of 12. That doesn't go to count 1, obviously.
Only count 2.
So that's something we need to tell the jury. The next one is CCP, that's standard language. There's nothing particular about this case in it.
State agrees to all the language the court has proposed.
So keep it. Don't give her a big head. Oh. Nah, she does do a good job. She does a good job. She's great.
Question, is this the last aggravated factor to both counts or just 1?
Your Honor, it's to 1 because we really have a hard time arguing with the child. Custodial authority, uncle.
Okay.
So you should be worried about the care of his daughter while unborn. We recognize that expression of an argument. But ideally, when that child, when IS was at his home, he is certainly the custodial authority over her. He taught her to drive, made her dinners. She stayed there a lot overnight. We heard all that testimony. He is his uncle by marriage.
Shut the
We
heck
heard
up.
also from Naomi that laid up a lot and or gone a lot.
You know I appreciate you, your mother.
Count 1. Judge, if I could do a little research on that with regard to the unborn child, I don't think I've ever seen that issue on a custodial aggravated factor with an unborn child. I don't believe there's any case law out there. I've never seen it, but I'm calling. I would just ask, let us have the weekend. But we ask for that.
Do we agree that, so the way I have them listed in the jury instructions is 1 through 7? Yes, ma'am.
Right, and we would just request to remove due to advanced age or disability, since we
They agree.
just have it read, IS was particularly vulnerable because Johnson Quillen.
Okay, fair enough. So it would read as follows: IS was particularly vulnerable because Jonathan Quayla stood in a position of familial or custodial authority over IS.
Correct.
Okay, so can we agree that 1 through 5 go towards both counts 1 and 2? And then count 6 is only to count 1, or excuse me, count 6 is only to count 2. Excuse me.
You agree, Ken, the 6th one is only for count.
And then the 7th one is what you want to research over the weekend.
Yes, sir.
Yeah, we need to come up with some language as that's how I tell the jury, because the verdict form is going to be different then. Which ones, I could say these are all the aggravators being alleged by the state, and then the verdict form is going to tell them which ones they need to find. But I think it's a good idea to tell the jury this is what applies to each count, so they're aware of it on the front end. And it could be as simple as I tell the jury at the very beginning, all these aggravators apply to both counts 1 and 2 unless told otherwise. And then when I get to number 6, I says this one applies to count 2 only, boom, and then we'll determine about count 7 on Monday morning.
Yes, sir, and I think that's common sense. They're certainly going to see the 6th one and realize that OPSI does not apply. The state agrees with the proposed language by the court in that regard.
That's fine with defense.
Okay. And I'll email this out when I'm done. That way you guys can see what I'm doing on the computer. Okay. Then the rest of the instructions are standard.
Yes, sir, the state has read every word of this, and we have no objections to the rest of it.
Okay, we'll get back to the one we're debating about here in a moment. Let's move on to, so at this point, the ballgame, the jury doesn't know anything, is not defined the mitigating circumstances. That comes in the latter jury instructions. I've gone over the pleadings filed by the defense. It looks like the only statutory one this defense is relying upon is the lack of criminal activity.
Correct.
Okay, everything else is just going to be a catch-all.
It's going to be a catch-all in character.
Okay, what I would ask that you do, because I'm going back and forth, it looks like some of the ones well, like for example, the one where it says list of catch-all mitigators, number 5 lists Mr. Breeden. I'm assuming that's just a copy. Understood. What I would like to have is a clean copy of every mitigating circumstance, statutory or non-statutory, the defense is going to rely upon that you want me to put in the jury instructions.
Sir.
I would ask that they be filed by end of business today, so the state's aware of it, and I'm aware of it going into the weekend. And in that pleading, you could list statutory and list the one you're relying upon, and then list non-statutory, and then basically every single thing you want me to list in the jury instructions.
Sir, Your Honor.
For the record, the state of Florida, other than I noticed they have to make a name change, no objection.
I understood. And my guess is what you're going to put in this one pleading is going to be everything you probably have in these two. I just want it to be, however you listen to that pleading, you're telling me that's how you want it listed on the jury instructions.
Understood.
Okay.
And that was a typo on my part.
Oh, understood. I understand. I just want to have one pleading so it's easier that way.
And speaking of typo, Judge, I provided it to the clerk.
I'll deal with that later.
Understood.
I got you. That's a
Just need
JAC.
clarification of the 5 days, otherwise they won't pay it.
Understood. I'll deal with that later. I think that was everything that I wanted to talk about today. I also worked on the verdict form. The verdict form is going to be different for counts 1 or 2. Supreme Court, I think sometime over the summer, came out with new instructions on these issues. I pulled it straight from the Florida Bar website regarding the verdict form. I'm happy to share sometime today what I've created. That way you guys can take a look at it. The only thing that's going to be different between the two is, as of right now, number 6. On the aggravating factors, that won't be on one of them than the other. I think the verdict form is a lot cleaner than what it used to be, if you ask me. That's all I wanted to cover today was going through the aggravators and going through the mitigators. As soon as you give me the mitigators, I'll plug them into the jury instructions for the back end at the conclusion of the evidence, and then I'll send that out. So as soon as you get me that information, I'll have it emailed out today. My assistant's out today. If you can email it to me directly, that'd be helpful.
Understood, Your Honor.
Your Honor, on that second one that you want to circle back, are you saying let's finalize that Monday?
I prefer not. Just give me some language to work with. I'm confused.
And I'll just so our record's clear, I know we talked a lot about just to put our final position. If it's red light and I'm tracking the aggravator from the exact statute, the defendant, the first degree murder was committed while the defendant was engaged in the commission of sexual battery, period. The state of Florida believes that tracks the exact language, simplifies it, it accomplishes any objection the defense has put on the record, and it makes sense. We would request that language. Engaged in the commission of sexual battery takes every single word directly from the statute, only plugging in the name of the numeric felony, and it accomplishes overcoming any objection.
You know what? Now that I read it again, I think you're right.
Judge, we agree, and obviously they're going to have to make those arguments, and we can make whatever arguments.
I think he's right, and the reason why I said it is because now that I've read it about 17 times, and it says, or flight after committing or attempting to commit, that language is going towards the flight portion of the instruction of the aggravator, not to the engagement. That's my fault in the way I read it. So I think the way the state just proposed it is actually accurate per statute.
The defense agrees, Judge.
Okay. So then it would read as follows: the first degree murder was committed while Jonathan Cuellar was engaged in the commission of sexual battery.
Yes, Judge, we agree.
Okay.
State of Florida.
Okay. What I'm going to do is I'll work on this afternoon as well, email out clean copies to everybody of the preliminary and the verdict form. I'll send out the charging instructions for the very end once I get the defendant's pleading regarding the mitigating circumstances. Is there anything you want me to inquire about with your client, Ms. Michelle or Mr. Davis? Obviously, he's been present the entire time we're going over the jury instructions. I'm sure he has an understanding as to the aggravators and mitigators and what we're doing.
Judge, I don't think it's necessary.
And he understands what we're talking about here?
Yes, he knows. We've gone through some of this with him already, so yes.
And he's aware of all the mitigating circumstances being alleged?
Yes, so now we've gone through that. That's been some time ago that we went through that with him.
Is there any mitigating circumstances he wants you to allege that you have not alleged?
Not that I'm aware of, Judge. If you want to inquire,
Yeah.
just to make it clear.
Mr. Quilles, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? All right, sir, you can put your hand down. So, sir, your attorney's filed a couple different pleadings regarding mitigating circumstances that he wants me to instruct the jury on for their consideration next week. The pleadings from August 10th of this year, he's going to file a clean copy of all this with the clerk later today and send my office a copy of it. Are there any mitigating circumstances that they are not putting forward that you want your attorneys to argue to the jury? They're arguing everything that you want them to argue. You're aware of the witnesses being called next week on your behalf, I'm assuming? Are they calling all the witnesses they want you to call? Excuse me. Are they calling all the witnesses you want them to call for purposes of phase 2 next week? And by that I mean, are they calling any witnesses, all witnesses you want the jury to consider for purposes of their sentence recommendation? Who from New York?
And Judge, they have written letters and provided those to my office as well. People who were going to try to make arrangements to come, but were not able to. And so, Judge,
How are the letters being presented to the jury?
I understand that, Judge. They sent them to me voluntarily. That's not something that I elicited from them. When they found out that that was not something that, there's no Zoom, there's no, just read a letter into the court type of thing. That was kind of I think that was just hey, we want to express our support since we can't be there, that type of thing. So,
Your Honor, just so the record is clear, the defendant wants witnesses to testify in penalty phase 2, not Spencer. The state of Florida would agree in any way whatsoever the court would accommodate that testimony of your including Zoom or any other format that he wants. The state of Florida, I know we have not called one witness on Zoom. That's the decision. What happened state objection.
and Judge, based on your prior statements, we did not believe that was an option, so we did not even.
Well, I don't think it's allowed, but if the parties are agreeing to it, given the phase that we're in, and the state's not objecting to it, I'm sure arrangements can be made.
Okay, Judge. Well, then I believe we would need to list additional people. I know specifically there are several that we've talked to. We probably would need a little time, Judge, to give that list, at least by the end of the day. I could try to get that to the state. If they wanted to speak to them, we could try to make them available. That way they would have an idea of what they would say. It's not going to be anything outside of character evidence that they've probably heard already.
They may not even want to depose them. I'll leave it up to them at this point.
Your Honor, if they make them available in any way whatsoever between now and Monday, the state will agree with this. Or that we want the defendant himself wants more witnesses to testify. The state will not do in any way to speak to them, even if that means Saturday, Sunday, and spring. I don't know, council has to work a lot of weekends, last 3 or 4, so we'll make ourselves available this weekend, even if it's just a Zoom call or a phone call. In any way, in any manner, they can let us at least inquire of them, even if it's sworn or not, but we'll agree to them pretty soon.
And then if you have those letters too, that letter may encompass what they're talking about as well.
Have the letters and we see it and they represent to us that's what's coming, maybe we would possibly elect not to speak to them in person or on Zoom or otherwise. So yes, I'd ask them just to give us the letters, and if that's the folks that are testifying within the 4 corners of what they have in those letters, we most certainly agree to that.
That I can give them today without any issue. Otherwise, what I'll do is I'll give the letters, confirm who additional he would like for sure, and then provide their names and phone numbers to the state before the day's out. That way, if they want to speak to them personally, or if they're, if it's sufficient just from what's in the letter, then maybe that will resolve it. I don't expect it's going to be 10 more people or anything along those lines, Judge. So I just expect to be a few additional people, grandmother, maybe a cousin.
That's fine. I'll get with courthouse IT regarding getting Zoom set up for that portion of it. What I'll probably do is whenever that testimony is being heard, have it heard in a block if I can.
Yes, Judge.
Get the jury a break, get it set up, get that testimony, get the jury another break, and then we can put the stuff away, given the phase that we're at.
Judge,
I guess
thank you.
the smart word will be used, but I'll get with IT about that later this afternoon and have it set up. Obviously, however we set it up, I want the jury to see the person, and so I'll get with the staff about that later today. What Zoom ID and information it would be, I don't know the answer to that. I will get that information as soon as I can figure it out.
Yes,
It
sir.
may be my normal courtroom ID. That's beyond my purview, though, how that would work.
That's fine, Judge. You let us know, and we appreciate the consideration. Thank you.
Okay.
Judge, I do have one quick thing to add to that. If they are appearing by Zoom for identification, is the court going to require an ID and then show their ID to be sworn in by the clerk? And I'm just asking so that we know how to properly prepare them.
Right, let the state have the opportunity to speak to them, receive letters. We may ask that they identify themselves to us this weekend, if that's the case. Ask for that.
Because typically when you have a proceeding of this, they go to a court reporter's office. They can assure who they are by a notary of some sort. Obviously, we don't have that capabilities, but if the parties are agreeing to the procedure, obviously it inures to his benefit, then I'll work with you guys on that procedure.
Just for the record, someone way smarter than me in terms of technology, just advised, we have used our paralegal and other person or patient with death this year. You take your laptop and you plug it in through the card. It will zoom in and it is showing on all the screens. I think you have it.
I'll talk to IT about that.
Yes, sir.
I would hope that they know how that works.
Of course.
But I appreciate that. That's a good idea that I'll mention to them. I'm not sure where the camera would be for the courtroom, so the witness can see what's going on in the courtroom. I don't know the answer to that, so it needs to work both ways.
Yes, sir. I mean, typically both devices have a camera and then whatever's being shown.
Oh, so you're saying the laptop would be the camera?
Yes, it's on the,
No, I'm saying how would the witness see what's going on in court?
you're presuming that the laptop has a camera and on their end as well.
So they essentially would be at the podium with the laptop, talking to them. Okay. Okay. I don't have a laptop that fancy.
I know in front of Judge Lester and Clay, we had a laptop that we use, and I inquired with the camera on the laptop.
So then essentially it would be, in that scenario, it would be defense counsel zooming in and that witness zooming into their Zoom, and all Miss Michelle would be doing is plugging her laptop into the device.
And when she's done, the state of Florida goes right to where she was, stands in front of the computer and talks to them.
And that way it's shown on all the all the video boards.
Yes, sir.
Do you have a laptop that has a camera?
Yes, we
Okay.
do. So that's not an issue whatsoever.
Okay.
If you want to do it that way.
What I may do is call IT and have them maybe come here early Monday. That way they can verify that procedure works. Otherwise, we'll be in. Otherwise, I may say, what's plan B just in case?
Yeah, maybe using yours as a backup, and there's a smart board there that we use in court. That would be the backup. But if that works, then we can give them the Zoom information have them set up. I can practice with them before. That way we know there's no issues on their end.
Yeah, go ahead and
Do that?
set that up on your end, and I'll get with IT and let you guys know.
Yes, Judge. We'll do that.
And so how many, Mr. Quez, how many witnesses is that? You said 3 to 4, your grandmother and cousins? Okay, so about 3, okay. And so we'll make that happen for you. And I'm sure council will work with the state of making that sure, but we'll make sure, obviously New York's a ways away, and we'll make sure the jury hears from your family. Is there anybody else you want them to call that's not being called now that you know family from New York will be able to present to the jury?
I gave instructions to my attorney to go to my aunt. That's more of that. I've been in here so long, so I don't know contact. She has all the contact.
Oh, who to contact New York?
Yes.
Oh, okay, outside those New York people and who your attorney's already calling, is there anybody else you want them to call? Okay.
We do have that, Judge. We have his aunt, extended family that's here, as well as the people from New York. And like I said, given the change here this morning, we'll work on that this afternoon.
Okay, so there may be more than just the New York people?
No, I think the only additional person was he suggested a couple. I will reach out today. I believe I've received letters from everybody that his aunt has already been in contact with.
Is the aunt up in New York?
No, she's here. She's been.
Oh, okay, I was confused by that.
No.
Is the aunt one of the witnesses being called?
Yes, she is.
Okay,
And she's been kind of coordinating with getting, that list to us. So I don't think it'll be any issue. Everybody that he's suggested, even today, that he's leaned over and told me, I've already had some contact with. I've already at least given their names, that type of thing. So I don't think there'll be any issue with getting that information. So outside of the people he suggested to us, I don't think there's anything else. If you want to,
they need to be available Monday afternoon.
correct. And obviously, I don't know that, but I'm going to tell them today.
They need to be, that's their chance.
Correct. Obviously, I don't know as we sit here because I've not contacted anybody, and I told them that wasn't an option before. So I will let them know today, and whoever's available, then I will, of course, give that information to the state. That way they can know in advance. I will do that before the end of the day.
And you have good communication with those people up in New York? So they respond quickly?
Yeah, we've never had any issue with responses
Okay.
coming from the family. That's never been an issue whatsoever.
Because my concern was them not getting back to you in time and what that does.
No, they actually sent letters, like I said, unsolicited very quickly, so that wasn't as soon as they found out that there was this going on.
Well, whatever number it is, get with the state. I'm sure they'll work with you guys, and we'll make the IT stuff work on our end.
Yes, Judge.
And we're relatively confident that will not expand our case any more than the half day we've already said.
State, do you have any, other than, I know you said a lot of your aggravators are listed in the evidence of the guilt phase of the case. Are you calling any additional witnesses outside victim impact testimony?
Your Honor, we thought about that. We will have the lead detective here for on our, in essence, our case sheet.
Okay, so obviously, it sounds like it would go to the defense case in chief rather quickly.
We have the 2 victim impacts, and maybe 3. I think two.
I guess my point is that not going to last 3 hours, so,
It most certainly will not.
okay. My goal would probably be to close Tuesday morning for you guys, just so for preparation purposes. If you guys end early on Monday, I'll go to closings, but if it's 4 o'clock, I'm not going to close. I'll bring you guys back Tuesday morning, 9 o'clock to close, and give the jury all day that way, however long they take. Is that
We've talked to the state, and I think the defense would agree that we are going to be prepared to do closings on Monday because we do not expect the information, and even in the depositions, of how long each of those witnesses took. I just don't see that being an all-day affair.
how long would the doctor be?
The doctor would be the only one, and that report is not extensive by any means, just because there's not a whole lot there. And so I don't expect her to be a lengthy witness by any means. Bob?
I agree.
Okay.
That's why we're meeting.
Okay, we'll see how it shakes out. The jury knows it's, Monday, Tuesday, so I believe I told them that, or early portion of the week, so we'll see what time it is. I'm assuming the closings won't be as lengthy as the guilt phase,
No.
nor will openings at that same time.
I can tell the court now, opening with, no additional evidence other than victim impact and talk a little bit about the aggravators. You're not talking about the opening at all. But on our 2 witnesses, at most, I think 3
Just remind me to read the jury instruction regarding the victim testimony before they testify as well. Okay, I'm glad we worked out the witnesses from New York from Mr. Quaylez. And is there anything else we need to handle today?
No, Your Honor.
Sure, Your Honor.
All right, I'll share everything I've been working on, and as soon as I get the pleading from you, Mr. Davis, please make it a PDF that's been filed. Send me the filed copy. I don't want a Word document.
Yes, sir. And just to be clear, so the style of the case, statutory mitigator, non-statutory mitigator.
However you want to parse it out, I just want one pleading that has all mitigators you want me to read to the jury. If you want to parse it out as to here's the one statutory one you're alleging, and then you want everything else you're alleging under the sun, that's fine. I just want one pleading I can refer to that cleans everything up, that I can basically say this is what I'm reading to the jury at the close of the case.
Sir.
And just send me the copy that's been filed. Send me that PDF copy.
Absolutely.
Anything else from the state?
No, Your Honor.
Spence?
No, Your Honor.
Okay, well, how about we get here at let's get here at 9:15. We'll make sure IT is working, handle any issues we need to handle. That way at 10 o'clock when the jury gets here, we can move promptly.
State will be present. Yes, sir.
Yes, sir, Your Honor.
All right, you guys have a nice weekend.
So it'll be 2:50. You guys, I'll stream it, but you guys don't need to be here. So for that's gonna be boring. But I'll stream it from 9:15. 7 Eastern. Right, this is doing my nothing. Hey, do you know what? Lucky that I got this Streamlabs mod. Say the alternate corner gifted membership to the channel. Do you know what I mean? Just so efficient. So efficient. Well, congratulations to Poppy for becoming a blue wench. I could take these off now. She's now a blue wench. I still can't get it to work. I don't get it. I don't understand. I don't understand. Why won't it? Right, hang on. Why won't this work? Well, oh, it's like she's awake now. Look at her, awake now. I have to wake her up every time. Do you know what I mean? So put in members. What's it called? In Streamlabs. Right, open Streamlabs desktop. Oh, desktop, navigate to sources. Yes, who's back? Back again. The Gilf is back. Tell a friend. Guess who's back? Guess who's back? Guess who's back? Guess who's back? Gilf is back. We love the Gilf. We love the Gilf. Hello, Gilf. You just missed a boring start of the stream. I'm trying to get used to this. Right. I might need your brother I might need to ask for you to ask your brother how to do the membership stuff. I can't do this membership thing. I don't know how to do it. I'll try to look at it now. So if I open desktop, right, let me open this up then. Open desktop. It says so Streamlabs. No, not that one. But oh, this is so hard. But I'm getting the hang of it, LL. I'm getting the hang of it, of this Streamlabs business. Starting to get there. I wouldn't say it was a genius, but I'm not far off. Yeah, no worries. There's no massive rush, do you know what I mean? But thank you. There's no massive rush. It's just more like, right, hang on, but I'm looking at Google at the same time, yeah. So open Streamlock desktop, fine. Navigate to sources. Right, sources. 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 Source, like tomato ketchup, innit? Sources. Right, let me get this up now. Sources. I can't find sources. I got no sources. What's in the studio tab? What's in the studio tab? Open Streamlabs desktop. Done, right? Guys, I've done it. Navigate. Hang on. Let's do this together. You and me were meant to be, walking free in harmony. One fine day we'll fly away. Something, something do wasn't built in a day. Hey, hey, hey. Hey, hey, hey. Hey, hey, hey. Right. So, what I have to do now is this. Right, this is my back end. Let me get that up there. So, it says, and if you go dashboard, now it says I've got to go sources. Where's my sources? Here he is, CloudBot, the bot. Where's my sources? You see? There's no bloody sources. It's not me. It's not me. I'm not going daft here. But where the fuck's the sources? Navigate the sources while you're in the studio tab. In the studio tab. Oh, okay, no. Oh, hang on. I think I know what it means now. Sources, yes. Go into. Right, select the type of source you want to add. No, that's not what I want, you idiot. Bloody bot, that's not what I want. That's not what I want. What I really, really want. I wanna. Da, 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 da. Right. How to stream to Twitch? No, I don't want that. So media, no. 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 So the PayPal, I've got that working. PayPal works. Ah, no, nothing. I'll just wait for Lady Law. I'll just wait. So, members count and put in some saucer. Hang on, we got something here. Is this saying anything to me?
Hey guys, today, we are showing you how to add your live subscriber count for YouTube or live follower or live subscriber count for Twitch on Streamlabs OBS. So first you click the add source button. And then, you click stream label.
Whoa, cool. Slow down now. Stream label. Oh, I'm sorry. I'm sorry. I still haven't got this right. The whole thing. Sorry, Lady Law. Stream label. I got one. I have. Yeah, that's not what I want. Maybe. Hang on. Add source. No. They make it so complicated. Just make it easy. I don't get it. No, that's not what I want. It's fine. I don't need this bot. Uh, um, no. Okay. Anyway, we will look at it another time. I will bow down to you, Lady Law, because I'm sure your brother's got it. I love your message, yeah. Fuck 'em. Fuck them, people. Right. So I'm playing about with this now. I think I've done this quite well. Considering this is my first time, we've only messed up about 20 times. I think I've done quite well. What do you guys think about it? What do you guys think about this compared? The only thing I don't like about this, right, is that I can't highlight the chat. That's the only thing I don't like about it. I can't highlight it. Apart from that, I think it's fine. Right, what have we got here? Um, no, don't want that. All right. What's it called? No, wrong one again. Do you know what I mean? That's all right. Let's see if there's a live one. Let's see if we got a live one. No. You don't have to be shy in chat, guys. You can speak if you want to. It's absolutely fine. Cartoons. I don't want to watch cartoons. It's all good. There's nothing interesting on, so that's fine. Um. All right. So, right, it's only a short stream today anyway. I hope some of you watched last night. What do you think about the whole thing with Matt Moore? Anybody here that watched it? Did you enjoy it? I mean, I'm probably talking to myself right now. I know you are, Lady Law. You're different. You're different. You're actually working. I know that. It's fine. But I'm talking about in general people that are here, and you didn't even watch Matt Moore one yet. So, but what do we think, guys? Anything? Whoever's here. Oh, okay. What do you think of the first half, though, Sarah? Was it all right? Was it okay? Oh, you watched the part. Okay. His connection was piss poor, but his I got a good chat with him about 20 minutes before we came live. Jesus, he's got a potty mouth as well. I loved it. I loved it. It was good. Good. I'm glad. I'm glad. It's nice. I'm prepared for negative feedback. I've had some negative feedback already on it, which is fine. And this is why I'm asking people if it's negative, it's absolutely fine. I've had a couple of pieces on it, um, but that's how we improve. That's how we improve. Well, I mean, not really because I don't listen to it, but I think overall it's a shame his connection was so bad. By the end, it was just unbearable. We couldn't listen. But as a man himself, he was good. Listen, not still have to watch the interview. Not for so it's good. Watch the interview, Minister. So from next Wednesday onwards, Mel, we are going to be streaming one day at a time. So one day of the trial every day for I think it's 2 months. I think so. Every Wednesday we're going to be doing it. Um, but yeah, it is. I've not seen it myself. I've not seen the trial, but everyone tells me. He said it's a boring trial. He said, but it's an interesting trial, and he was saying about how his attorney didn't have much time to prepare for the trial. She had 30,000 pages to look through, and he's like, she knew more than what he did. Do you know what I mean? He said that she was the best of the best, so she was fantastic. And he's got to, come on now and again to, excuse me, update us as well. And he's going to come at the end to answer all our questions. But in the gist of it, it's basically he was accused of killing his wife. It's called something like staged suicide or something. So she committed suicide, but police were like, no, you killed her, and staged it as a suicide, essentially. But the interview, hopefully he can stand it. He does go into his feelings and stuff like that. He has watched the video of the openings, but what I'm going to do, I'm going to play the openings again from scratch. He watched that, and he reached out to me. I know he's reached out, I think, to a few podcasts as well, so he's very keen. It wouldn't surprise me if he's going to be in chat and stuff when we watch it. He said he wishes he could be here every day, as in to watch it with us, but he can't. So I'll offer him to come on whenever he's available, or he'll just watch it and chat. The one thing I do know is he's definitely coming up at the end, and we might have him on in the middle somewhere as well. I don't know. I don't know. See what you guys think. I enjoyed it. I know some people didn't, but overall, I thought it was good. I know connection was an issue and stuff, but hey, it is what it is. I'm not gonna hold that back on him. It's just obviously Wales is better than America with technology and stuff. Who'd have thunk, eh? But it is what it is. It is what it is. It was not a bad crowd. That's like 20 odd people there, which is good. And mostly thank you to the Zachariah Anderson. I tried to sneak in Zachariah's case as much as I could. Because there are similarities because, they were after him, accusing him of murder without a body being found. And Zach had the same, obviously. Obviously, in the end, they did find the body, but that's not the point. But yeah. So yeah, hopefully people start watching on Wednesday. I think it'd be quite good. I know Sarah P. She cannot wait. She is like woo. Every Wednesday it's gonna be like a hump day for Sarah P. She's gonna love it. Her husband's gonna enjoy it every Wednesday as well. So we got that. Put that on as well. There, fine. My keyboard thing came out. Oh, I don't know. I'm presuming everyone else is working. It's just gone quiet. I don't know how to do the members thing, but we'll figure it out. PayPal's done. Excuse me. I know how to do PayPal. That's working. It goes straight on the screen. I think if you subscribe, though, it doesn't always put you on the screen. I think you have to be live, as in you have to be seen and not private for it to pop up. I'm not sure. I've set it up so that it does show us, and it should show us every member as well. Remember? You remember? So yeah, we'll see that bit as well. But yeah, it's annoying because I like to see how to set little goals. End of October total 150 members. We're not going to reach it, but if you don't have goals, then you're not going to. I'm sure that some people think that's low, but hey, we're a low channel. Yeah, it's interesting. I don't. It's been a long week as well. Today I did not get up till 9:45. And even then I was been drifting off all the time, leading up to this trial. Sorry, into this stream, knackered. So I'm looking forward to now a nice rest this weekend. Nice, beautiful rest, and what do you call it? Relax. I was thinking about changing my sleeping pattern to Eastern time, so that I can do more then, like in the mornings and stuff. Because I can't do normally 2:30 in the morning, my time, streaming, and then get up at 7 and stuff. I'm too old for that now. And if I do later streams, that means I can get people like the Gilf on. Do you know what I mean? And the MILF. Like the MILF wants to come on a bit more as well. So, because at the minute it's awkward because people are working and stuff like that. So it is hard. I don't know. So we'll see. But I'm excited to stream them more stuff. That's for sure. Oh, I had a premiere today. Let's see how that did today. I did have a premiere. I didn't realise it was on when it was on. But that doesn't matter. That does not mattero one bito. Ooh, 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 ooh. Where's this YouTube studio? Let's see how many we gain. Let's see. Oh, geez. Right, let's have a look here. Content. There we are. We're hey. I say we're hey because monetization's on. My last 2 streams have been limited. Blame Sarah P, not me. Okay, 9 comments, good. So I did alright. And we'll see how well that did this morning. Beep 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 beep. Analytics. Videos. Oh, I did okay. 40 people watched it. That's okay. And 40 views. So, I don't know. I never know what to do with Premiere and stuff like that. Anyway, that doesn't matter. It's all good. But I did get limited. Damn. Damn, damn, damn. Damn, damn, damn. So I don't know. I don't think I've got anything else for you guys. I know, Lady Law, your membership is running out today. I've got a host of people. Let's have a look. Whose membership? Okay, there's one there. So yeah, yours is running out today. 7. What would it be? 12, 1, 8 o'clock. So in 2 hours, Lady Law, you'll no longer be a member. And Solomon and Sandra. Oh, Heidi, Toxic, Dave. We're losing everyone. There's another one. I don't mind if we lose that person. Okay. Comes around so quick though. Anyway, fine. I just checked that. So yeah, I always try and check where we are with members and stuff. So yeah, it is what it is. It is what it is. I think we're gonna lose quite a few in the next couple of days, which is fine. Because if they don't want to renew, that's up to them. That's up to them. But right, with that, I think I'm going to shut up and shut down. I've got nothing to say, and it just means I can actually have dinner normal time tonight. I'm not sure what I'm going to have yet, but it also means I'm going to have an early night tonight because I am. You know, when you're so sleepy, you just want an early night. So I have an early night tonight. I've not been to the gym. Well, I haven't walked or done anything today, so I'm not going to do anything today. I'm just going to relax. And then tomorrow, I'm doing American breakfast tomorrow, but at dinner time. I'm going to do fluffy American pancakes, have sausage with it, have some black pudding, white pudding, fried egg, and some golden syrup over it, spread it. So having that, I'm going to make enough pancakes for tomorrow and the day after. So I'll have that, probably do it for my whole family. Some of my nieces will love it, some of them won't. So I don't know, I'll just make enough for everyone. If they don't want it, more for me, more for me. So that's the plan tomorrow and Sunday anyway. Cooking dinner for everyone, but American themed. I think tomorrow we'll have sausages, and then Sunday we'll have bacon. I think mix it up a little bit. You don't want the same thing twice. Although I'm sure most people in this chat would prefer to have sausages over and over again. Dirty, dirty girls, but you know it's good. It's good. And not just the girls, some of the boys as well. That's fine. Right, I'm just waiting for this to turn 2 hours. That means then I've done 2 hours. And yesterday I did over 12-hour stream yesterday. Some people call me a legend, but then most people call me a prick, so can't really win. Anyway, 30 seconds left, and then I'll love you and leave you. I don't even know how to shut this stream down. Oh, it's down here. And stream there. Couldn't even start this stream this morning. So, yeah, hopefully you enjoy it. If you haven't seen it, have a look at the Matthew Moore trial. Have a great rest of the day and autumn weekend. No worries. Thank you, Sarah P, as always. And hopefully you look at the Matthew Moore trial. Anybody who hasn't seen it, take a look in my library on YouTube. It's there. And take a look. There's a condensed version as well as a video. On the live one, we just talk shit for another like hour afterwards. Had nothing to do with it, so you can skip that if you want. Anyway, with that, love you all. Take care. Have a great weekend.